What's going on, everybody? We're just starting to watch day 52 of the YSL Young Thug trial, and, we're picking up live together, so let's see where we are. Let me know if the white noise, I have my fan going, but if it's too loud, I just turned it off. I turn it off, it gets a little hot in here. So let's do this. Let's keep it on. Let's keep the fan going. Hopefully it's not too much of a droning. Let's put some classical music in the background when I can.
Oh, you see.
Hopefully this is... Just trying some classical music to break up the monotony of what a trial is really like. This stream started approximately 20 minutes ago. I wonder if it's coming through at all.
We're not taking
Oh.
Is that where it comes in? Oh, yeah. The nominee to the president.
Oh boy. We're good. We're good. Just want to see if you can hear the classic music, the Mozart on the stream. No, but you can hear my kids screaming. So that's good, right? Is the door closed? The door is closed.
All right. Let me ask the state a question. I know that we have touched this before, but does this purported 150 witnesses comport with the rest of the accounts or overt acts that you attempted to prove in your case in chief?
Yes, this is the.
All right.
I think I understand the court's question.
That's the court, not me.
The number of witnesses. This is the most pared down. This is what we expect that we will be able.
They're not getting the classic,
We
the
hope to be
Mozart
able to
in the
prove
courtroom. Don't
everything that
worry.
we intend to put before this jury in our case in chief with these witnesses. If something goes differently than we anticipate, if some objection is made, if that is sustained, that requires that we call in an additional witness here or there to prove particular
Chat, let me know if
points,
it's too loud.
then we
If I should turn it down or just turn it
would,
off.
Supplement that list to
Oh,
that
no.
extent, but we don't expect that.
I didn't mean to
will
just blow out your
increase our
ears if that's
numbers
what
by
happened.
any, great percentage.
I didn't realize I was still in the
So
Mozart
this is
fiddle. the volume.
entirety of the rest of what we anticipate presenting to the jury in our case in chief. So it includes the counsel on the indictment. It includes overt acts, intrinsic evidence that we intend to introduce. We have served upon counsels for the defendants all of the acts, intrinsic, overt, that we intend to introduce evidence of. And so there's nothing within those witnesses that is not contained in the information that we have provided in terms of what we intend to prove. But this is as pared down as we've gotten it.
Okay, so these are the list of 150 are your the witnesses you will call.
Yes.
Okay. All right. Here's what I want you to do. Pursuant to OCGA 1716.3, I want you to update your witness list. You have the ability to call anybody that, you know, to supplant or supplement, depending
For any of
upon
those
what is-
wondering what we're
depending
watching,
upon what other
it's
evidence
day 52.
is adduced or is presented that may require you to impeach or rebut or the like.
It's Judge Earl
to
Glanville,
to
I
account
believe.
for variances in presentation of evidence.
Judge
So
Glanville.
I'll
I don't know
allow
his
you
first
to
name.
amend to supplement your witness list, but for good cause. But I want to see the 150. I want to see them in terms of law enforcement and what they're going to testify to, and lay witnesses and what they're going to testify.
My
pursuant to
dog
counts,
is trying to get my
overt acts,
attention.
and/or
You hear him?
counts,
I'm sure you can. Here, let me.
and any expert witnesses that you were going to call.
Okay. So that I understand, the court isn't asking that we give the strategy to. The court is just saying, generally speaking, this act, this, that, this, the other.
At this
Okay.
point, there's not any. One of your predecessors told me once, said, "I'll give you my entire file because if you can beat me with it, you deserve to win." And I think at this point in time, the caliber of lawyers that you have in this courtroom, there should be no surprises. And
Agreed.
and
Very
I'm of
good
the opinion
lawyers.
That more disclosure just fosters
I understand what
openness in the proceedings and with what's being presented.
Oh.
So at this point, it's not like anybody's going to be surprised with anything you come up with. At least you shouldn't. There shouldn't be. But I think that in order for us to keep this thing going smoothly, or as smooth as possible, the less interruptions that the court has, the better that.
Wanna see the dog,
better off
Zach?
we'll be in terms of
Zach Rockstar?
evidence and presentation in front of this jury. So I want that by tomorrow morning, because what I'm going to do is I'm going to take a look at my calendar, and we're going to kind of block it. I'm going to see whether or not we are going to meet 4 months or not.
that does not include
Huh?
the length of time.
Well, you can come on the weekend, Mr. Matthews. So don't worry about that, okay? You let me take care of that. But okay, but that's part of the
The
calculus.
dog has moved on to greener pastures. I don't know where he went. Zach's stream.
I know that.
When I hear him
I
come
know that,
back,
but what it
I'll
does
go
is
grab
kind of
him. But he's
puts
not
us
outside my
back
door
at least.
anymore.
I'll know, and your colleagues will know, hey, where we are in terms of, so I can start to plug
I
and
agree,
play
though.
and see if we're behind. Because we're behind, I'm gonna make you come during the weekends.
This is so far today has only been about getting back on schedule.
We need to kind of press a little bit harder, or else, as Mr.
Dogs
Atkins
would
Weinstein
make it
said,
better.
We'll be here to 2027, and that's not what I
100%.
want for this jury. We need to put this case to them in a fashion that is fair and reasonable. But I think that at this point in time, Ms. Love and all defense counsels, I think if you iron out and we don't have these hiccups where you all are like, where the state says, well, we gave you 3 things in discovery and now we have 5, and the defense says, well, I need to take up these other 2, which we haven't been given, or we got them this morning, or got them a couple of days ago, and I haven't had their opportunity to do that, and you want to go ahead and present them. So that's why I'm saying, if you all talk with one another, I mean, you might be able to, I know that you want to.
Hey, if you haven't already, hit that subscribe button. I'm sure a lot of people here are subscribers, but if you're not, you know, I'm trying to get to 1,000. I'm almost there. I'm like 800 something. So
do that because of
like, share, subscribe, all the things they say.
I'm going to help.
Trying to get my corner in law tube squared away.
To the second point that the court will be implementing in order to facilitate the presentation of the information to the jury.
That's the exclusion?
Yes, of any documents not timely disclosed. So when we stand up, Your Honor, to present or to show something to the witness, it will not include anything that has not been served. But what we are doing is showing to counsel for the defense.
Oh. Wasn't me, was it? Maybe it is. Maybe it is. Oh. My computer ran out of memory, and I'm not sure if you're still getting this or not. I'm not sure if you ever stopped getting it. I certainly crashed myself as far as understanding what the heck was going on. All right, let's see if we can open up the essential stuff here. Connect streaming software. So I'm not sure if this was cut off or not. Let me know, chat. Did you ever sure if this was cut off lose? Or not. Let me know, chat. Did you ever? Oh my God! This was cut off. I got okay. There we go. Let me know if we lost a connection or if I guess my computer lost memory. I guess Chrome tabs. Now this is a problem that I have right now. I donated how much is a sticker RAM? 8 gigs. So I donated 16 to my son's PC, and leaving me with 16, which is a solid amount of RAM. But actually, if something like Discovery, the files can be very big, and I've had trouble opening some things because of the 16 gigabyte RAM limit. So that's interesting thing how RAM technology and law kind of overlap in some ways.
If you already.
Let me know if this is too loud,
what I'm finding
not loud enough.
Your colleagues say, nope, we haven't gotten that. But you should be able to tell me, Judge, we gave it to him on June the 15th, and it was in
this has just been the judge coming down on the state for not getting things in a timely manner, forgetting things. I think the problem is the defense counsel, Mr. Steele, is so good. He's sharp. He's on point. And so if he says I didn't get something in time or they didn't give it to me, the judge is gonna.
I will make that as part of the
make
defense
note.
if they wish to go ahead, and as long as it falls within the rules of.
Were we enjoying the
remember, they're not in their case.
The classical music, Mozart, or was that louder? Yes. Okay, hold on. Let me get that going.
That don't necessarily apply to them the way they apply.
That should be good
at this time. And I know that's.
And then I had some Mozart going before, but I had a really weird, I guess, too many tabs open.
To the extent that any defendant's going to use.
Don't know what happened.
Any evidence that I'm going to need to rule upon.
Oh, it's good. Good.
I
And
do
then,
need as much as
yay or nay on Mozart? I like it, but I can see how it's distracting. So
let
me put that on. Something like that. If you can even hear it, I'm not sure.
Say we don't have any if we don't know what exhibits we're looking at, so we're just asking the court require that we be given a physical copy.
But a lot of times, this is evidence that you've already.
Am I losing you?
It is, and so if they're giving it to the witness, we don't know if.
Let me know, chat. That's good. Good. All right. And if it's too loud, I can turn it down. I think a little. I'm not a sound guy, but I can figure this out.
On a computer, if we have a physical copy of it, like we provide to them, labeled already, then we can make a more expeditious announcement.
Might be a little. Oh. That's good for me. Okay. Now, dare I try to work on
To
color
the extent
correction.
that the defense has any materials,
I don't
it
think
would be
that's any
helpful
better.
for you to show those to the state prior to you, prior to your presentation, so we don't have delay to the extent that you can. So I'll make that part of my order, but it's really going to depend upon.
If you haven't already,
And, Your Honor,
guys,
I don't mean
road to
prior to
1,000,
this. I mean, prior to
800 somewhere in
saying
there.
we're
So
approaching
if you
with
can,
the
drop that
pictures so that we can
subscribe,
at least
likes, and
know
shares
what
if
it is
you
that we're talking
where
about,
appropriate.
like offense 1 through 12. If we just have a copy of them, that would be great.
Well, I'll say this: as long as if it involves anything that wasn't disclosed in discovery, because you all should have those. I mean, Ms. Love, I think part of it is they're using evidence that arguably they got in discovery. So that shouldn't take that much. That should not take much looking at, nor should it be a surprise to you. However, if it's something that's not been provided in discovery that they wish to go ahead and examine, I would say that probably needs to be disclosed consistent with reciprocal discovery rules.
So this is kind of a painful part of the trial where we're getting the state getting a little bit of a slap on the wrist
No matter
for
what it is, just so that it's labeled, so that we can
not moving
properly
things
speak,
along.
that it's labeled, so that we can properly speak to it.
Let
on
me
the
close
record.
any extra
They know
tabs
that
just
there
in
are
case here.
12 pictures that the state has provided in discovery, and they are calling them defendants 29 through whatever. If they would simply say, okay, here are the pictures so that we can speak to them even when we get up to redirect. Okay,
8 minutes or so, I'm gonna have to hop off. I'm gonna make the stream from the top,
So
pull
are
it
you
down, make
saying
it bigger,
it's a labeling issue?
and it should be a pretty quick call.
Which exhibits comport
So I'll be
with
back
which
on.
defense number. We have been,
But stick around.
we have had the
You don't need to see me.
where a computer is taken to a witness and the witness is shown unnumbered photographs, and we have had to stop and say, we need to know what
Can't
is
the
being
state just
shown
move on and be
how
like,
you have labeled them so
I
that we
understand.
can
they're
speak
dragging
to
this
them.
out?
I understand. All right, so both sides can do that. Remember, if you show a witness a document, even if it's for refreshing recollection or whatever, or it's not admitted, it still has to be identified for purpose of record. So I'll ask that all of you do that. All right. What other issues haven't I dealt with pursuant to your motion, Mr. Weinstein?
Thank you, Your Honor. I just want to get some clarification.
Sure, to the extent I
I'm sure
can
the
give.
court understands what I don't understand. When the state says they have 120 days of direct examination, that's 120 court days, correct? So we're looking at about 6 months more of their case in chief, assuming we ask 0 questions on cross-examination. 120 days, is that 4 months? Or is that,
That's-
if we're going 4 days a week, for example, are we talking 30 weeks?
We're talking 120 days.
120 court days.
Are you talking about 100? Yeah, 120
good question.
court days.
120 court, assuming no, and then we have to add in our cross-examination. So we're
Yeah.
here with the state's case in chief through the Super Bowl
That's 6 months.
or more.
Yeah.
Okay.
And Your Honor, that is a it's not precise, and I can do more. It's as precise as I can give to the court at this moment. And Your Honor, I have stated to the court and to counsel for the defendants where it was that we were trying to conclude this case by.
Your Honor, I'm sorry, can I go? Yeah. Your Honor, courts in the 11th Circuit, the 7th Circuit, the 5th Circuit, the 3rd Circuit, the Western District of Pennsylvania, the Northern District of Iowa, the Eastern District of Kentucky, the District of Mass, and I could probably go on and on if I had more time to research, have used the combined power that you have under 403 and 611 to limit witnesses limit the number of witnesses, and or put time limits on the state. What I sent you this morning, just to clarify, and I should have made it more clear in my email, and that is my fault, was those were not additional arguments or amendments to my arguments. Those were courtesy copies of cases that were cited in the motion or additional cases that I was going to use in my argument. And that was just for the convenience of the state and for the court, so y'all didn't have to pull those up. But they weren't last-minute arguments. But Your Honor, and I'll sit down after this because I do believe that you've already made up your mind. But I would just ask the court to reconsider, because I do appreciate that you're trying to grab the bulls by the horns here and make us more efficient. And I don't doubt that those 5 rules that you've put in place will make us more efficient. But we're still trying to be more efficient at something that is going to go on for years. This length of time doesn't include our cross, and it doesn't include our case in chief. So while the state says that I cannot ask for what I asked for under 403, fine. Okay? Why don't you put in time limits? It's done over and over again by courts, Your Honor. Because right now, 150 witnesses, 120 court days just of direct examination.
Oh, I
We're
got
going to
that
be
call.
making Super Bowl bets with each other in 2026, Your Honor.
Do you have any Georgia case law that limit the length of witness testimony, the time of witness testimony? Because ordinarily, it's a thorough and sifting examination.
Exactly.
Oh.
So I do not have Georgia case law, but U.S.
Can't
Supreme
add a
case,
scene
U.S.
while we're.
Supreme Court
So I was
case
gonna.
law under
I'll just have to
Getters
pull it down
says
here.
that you are not a mere moderator. That if truth and fairness
Myself
are not
go
to be
away.
sacrificed, the judge must exert substantial control over the proceedings. And don't misunderstand me. I understand that you have exerted control. But what I ask is that you listen to what some of these other courts have done. The Reeves case, okay, the Reeves case, Eastern District of Kentucky, it's not controlling. You don't have to do what they say. But I will tell you, it's been cited 69 times throughout the U.S. about how a court needs to get a hold of a case so that you are running the case, Your Honor. You are controlling the court, not either of us, not the state, not the defense. I mean, you read my briefs. You know what they say. I'm not going to repeat it. But if you leave it up to us, we're going to do everything that we can to put on as many witnesses as we can to hammer home our case. And unless you put some kind of control, as we can see by another 150 witnesses coming out, unless you exert some type of limit, we are never going to get through this. Even working on the weekends, which I really would rather not do. Even working on the weekends, we're not going to get through this case, Your Honor. And let me add something else, just briefly, and I know you don't want to hear argument, but I want to mention something that wasn't specifically in there. We are losing our jurors. We are losing our jurors. I look over there at them, and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out. Tuned out. In a study from 1987, looking at long trials being more than 20 days, and short trials being less than 6 days, in long trials, 46% of the jurors found that evidence was difficult or very